nouveau sponsor, les coûts du congrès viennent de diminuer rapidement. Nous allons avoir deux voix. La première voix sera celle de Carmen Herrero qui va présenter la constitution de sociétés filiales ou d'une succursale en Espagne, et ceci par une société provenant d'un pays étranger. Et ensuite, sans transition, Domenico Tavacelli va présenter la situation pour l'Italie, mais uniquement sous l'angle de la constitution d'une filiale. Je crois, Carmen, que tu peux commencer, même si malheureusement tout le monde n'est pas encore tout à fait là. Dans 30 secondes.
Good morning to all. In order to make the long story short, I'm going to focus my presentation in a practical view of the different kind of legal forms applicable to foreign companies in Spain and which differences are between them. In Spain, one of the best ways of implementation of a commercial company from the European Union can be through the establishment of a subsidiary or a branch. Generally speaking, the requirements, necessary procedures, and costs related to the setting up of a branch of a foreign company in Spain are very similar to those of the setting up of a subsidiary. Regarding definitions, the subsidiary is subject to the legal economic control directly or indirectly from the parent or holding company. This control is exerted through titles that gather over half of the voting rights. It's a separate entity and it has own legal personality. A branch, on the other hand, is a secondary establishment operating as a permanent representative of the parent company. It doesn't have its own legal personality, so it's the same legal entity as its parent company. I'm going to show you the main differences in this comparative chart. A subsidiary has own personality, but a branch doesn't. A subsidiary doesn't have the same corporate purpose as a parent company, but the branch does. Both of them are permanent. A subsidiary has own liability limited to the assets of the Spanish company, and a branch doesn't. It's unlimited to the assets of the parent company in Spain and also abroad. Both of them have operational autonomy. A subsidiary has a specific legal form, a PLC, SA in Spanish, and LLC, SL in Spanish, and a branch doesn't. Both of them have capital disbursement. For a subsidiary, it's mandatory, a minimum of 60,000 euros for a PLC and 3,000 euros for a LLC. And for a branch, there is no minimum. Both of them have responsible authorities, subsidiary, board and administrative authority, and branch, a legal representative. Both of them pay taxes in Spain. A subsidiary pays all of them in Spain, but branch only some specific. But both of them pay corporation tax. Both of them have accounting obligations. And regarding the staff, in the first case, it's hired by the subsidiary, and in the case of the branch, it's hired by the branch, the Spanish branch. So the final decision between choosing a subsidiary or a branch in Spain may be prompt for commercial reasons. For instance, the image projected by a subsidiary shows more stability and confidence than a branch, and also for legal security reasons. A subsidiary limits the responsibility of the shareholders. Okay. And here we have the procedure, different characteristics for both of them. Both of them are very similar. The subsidiary needs to ask for a negative name certificate, but for a branch is not mandatory. They can use the same name as the company of the region only ending with SUCURSAL en España. Obtaining tax identification number of an appointment of the representative of the parent company to the Spanish tax administration is for both of them. They also need to do an act of real ownership that I think is almost the same in all European countries. The public notaries must identify the natural or legal person who ultimately own or control, direct or indirectly, a percentage higher than 25% of the capital or voting rights of a legal entity. This is for prevention of money laundering and financing of terrorism. So this is needed, and also a public deed of establishment in the case of the branch and of incorporation in the case of the subsidiary. Both of them before a Spanish notary. Registration in the business registry is mandatory for them, for both of them. And about census procedures, registration on business tax for both, registration on value-added tax, registration on social security, and obtaining the opening or operating license before the corresponding city council is not needed up to 750 square meters for both of them. Capital disbursement is mandatory for both of them in a Spanish banking entity. Here you have the procedure timeline, which is similar for both cases. In the blue line, you can see the steps, and underlined, you can see the estimated terms for each step. The steps described below. No, don't worry, you're not getting blind. I will do a better soon, don't worry. The steps described below can be done in the meanwhile. We are doing the steps mentioned above. And here we have, with a better vision, the steps. Okay. The first steps is the case appraisal. We studied the case, and it will take us around 48 hours, depending on the complexity of the case, but maximum 1 week. Then we issue the letter of engagement and our estimate of fees, and we do a draft of power of attorney, bilingual, in French-Spanish or English-Spanish, to be signed in the origin home country. So once we send this to a client, it will take us, will take him between 15 days and 1 month, because they have to legalize all the documents that we will see later, and also to do the apostille and the sworn translation. This step could be longer. It depends on the client. It's not our fault. So these are the original documentation that we need to prepare the deed and to do all the procedure. The extract from the business and companies registry, straight to cabis, from the country where the parent company is located. It's a certificate that proves that the parent company has been incorporated properly and in compliance to said country's law, and that it has been duly legalized or apostilled. The foreign company's bylaws, the accreditation of founding partners' identities. If any of them is being represented in the setup of the subsidiary, we need a power of attorney. And if that power of attorney was granted abroad, it must be duly legalized, as I have already said. So we need also the power of attorney granted by a parent company to the representative of the Spanish subsidiary. The power must be formalized before a French public notary. And the next step is asking for an IF or an IE of the non-resident partners and administrators. This step used to take us longer a few months ago, but because the Foreign Police Office, where we have to ask for the NIE, the tax number identification for a physical person, was completely collapsed, and it took us 2 months. 2 months. So we have solved this problem because we have found another foreign police office outside the city, and we can get it in 1 week. This is the good news for you. And the other NIF, the other number, is for the corporate person. So we can ask not in the police office for foreigners, it's in the tax agency, Spanish tax agency. These are all the details that I'm not going to talk to you about, but if you are interested, you can check it. The next step is opening a bank account in a Spanish entity. It will take us between 2 and 3 days because we have to go to the bank entity. If we have the power of attorney of the client, it's okay. If the client wants to come with us, it's okay also. But the problem is that they have to do the money transfer of the disbursement, the capital disbursement, and maybe the money transfer will take 2 days or 3 to arrive in the bank's Spanish entity, and they have to issue the certificate of disbursement. Until we don't have this certificate, we can't go to the notary to sign the deed. And these are the steps that we can advance in the meanwhile. We are waiting for the original documentation and legalize it. So we can ask for a clearance certificate of name, which is regarding others that have already been registered in Spain before the Central Business Register. If the name has not been registered before, it will be registered for 6 months. And when referring to the subsidiary deed of incorporation, it will be valid up to 3 months. So we have to sign the deed within 3 months. And we're referring to the description in the registry, it's valid up to 6 months. And the other step that we can advance is the drafting of bylaws and the deed. This process can be carried out in parallel, as we have the name, and around 48 hours it will take us, and except for the branch, which uses the same as the parent company. So once we have all the documentation, we can go to the notary. You know, a Spanish notary is the person who is in charge of doing these official documents. The lawyers can do this in Spain. So we have to go to a notary to sign the deed. It will take us 2 or 3 days after getting the certificate of disbursement to check all the deed and things. And the same day, we can take the provisional NIF of the subsidiary or the branch to start working. To sign the deed of incorporation, we need the following documents. The agreement to set up a subsidiary or property powers to the person who can do it, and the bylaws, the certificate of disbursement, passport and legal representative's name, a clearance certificate of the company's name. This declaration of foreign investment is done by the bank entity, so we don't have to do it, and it's not needed really for this. And the original of the power of attorney of the representative. So, once we have the provisional NIF of the subsidiary, I would like to tell you that the company can start working. You know, it will take us some time to be registered, the deed in the business registry. So, under the unlimited responsibility of the shareholders, as an irregular corporate company, the company can start working, and under condition that it has been registered in the business registry, and then, in that moment, we can take the responsibility of the corporate back in time to the date of the deed, the signing of the deed. So the good news is that maybe it will take us 1.5 months to start the company view. After this step, we have to do the submission of a corporate corporation tax. It has a strange name, ITP and ID tax, but for better understanding, it's corporate corporation tax. We can do this in the same day as we take the deed to the registration, to the business registry. And after that, it will take us 1 month to pick up the registered deed, because it's the time it takes the registry. And definitively, it will be ready within 2 months, more or less. And the last steps are the following. We need a power of attorney before the tax agency to receive electronic notifications. It will take us 2 days, because we have to do it before an Spanish notary also. We take the partners' books and minutes to the business registry to be registered also. It will take us 1 day. And after that, in our law firm, we can offer all the accounting service and tax, legal advisement, so everything. We can run the company from the near future and everything. So the whole process, it will take us more or less 3 months to finish all the version. Okay. So I'm going to pass this because I have already talked about it. And a company branch follows practically the same procedures to be set up as a subsidiary. Next, we will see the differences. Obtaining the documentation, the same documentation is requested. In addition to that, the Spanish consulate from the country where the parent company is located must certify that it's been set up following all the country's legal requirements. It must also be duly legalized or apostilled. In the case of signature countries of the Convention, said legalization will be done through the apostille of the Act. And setting up an agreement of a branch in Spain, we need this agreement from the competent authority of the foreign company, and this agreement should specify the name, the registered office, the corporate purpose, and the appointment of one or more permanent representatives for the branch who must be legally residing in Spain. This is very important. And also the power of attorney, duly legalized. For clearance certificate and validity of establishment, I have already mentioned before. And this is the main diagram I want you to talk about, because we have here all the legal forms applicable to foreign companies in Spain. I have already said the characteristics of subsidiary and branch in Spain, but we also have 2 more legal forms, as a permanent establishment and by a non-residence with no staff. Relating to legal address or registered office, a subsidiary, it has it in Spain, and a branch taking into account the example of France for the origin country. It will be between France or Spain, and also for permanent establishment, and the non-residents in France, sorry. Regarding taxes, subsidiary pays all the taxes in Spain. Branch in Spain only some specific ones, and permanent establishment in Spain only those corresponding to operating in Spain. And for non-residents, it has a special tax treatment, the income tax for non-residents. Regarding capital disbursement, subsidiary and branch need to do official disbursement in a Spanish banking entity, as I have already explained, and permanent establishment doesn't need an official disbursement in Spain, and also the non-residents. Regarding staff,